Corporations are often incorporated in one state, but have significant ties with other states through, for example, the business's headquarters, activities, or shareholders. As states often have differing laws governing corporate affairs, it's important to understand which state's laws govern a corporation's internal operations. In VantagePoint Venture Partners 1996 versus Examen Incorporated, we explore a choice of law principle known as the Internal Affairs Doctrine. Examen Incorporated, a Delaware corporation with both preferred stock and common stock, conducted a significant portion of its business in California and also had California-based shareholders. VantagePoint Venture Partners owned 83% of Examen's preferred stock, but none of its common stock. In 2005, Examen planned to engage in a merger, a transaction that VantagePoint opposed. Under Delaware law and Examen's certificate of incorporation, the merger required the approval of a majority of the shareholders of Examen's preferred stock and common stock, voting as a single class. In such a combined vote, VantagePoint's proportional interest in Examen was insufficient to allow it to block the merger. But VantagePoint alleged that Examen's affiliations with California meant that it qualified as a quasi-California corporation under California Corporations Code Section 2115 and was therefore subject to California law. Under California law, the preferred shareholders would have been entitled to vote as a separate class. Because VantagePoint owned 83% of the preferred stock, it would have been able to block the merger. Examen filed an action in the Delaware Court of Chancery, seeking a declaration that Delaware law governed the relationship between Examen and its shareholders, and its preferred shareholders, therefore, weren't entitled to vote as a separate class. The Court of Chancery held in favor of Examen, and VantagePoint appealed to the Delaware Supreme Court.